Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session. Pursuant to adjournment, God save the Constitution and God save the Honorable Court.
Please be seated. Good afternoon. We have one case on our docket today, Metwater Vista Ridge versus Blue Water LP and Blue Water Vista Ridge. The appellant would like to have time for rebuttal.
Yes, Your Honor. I'd like to reserve 3 minutes, please.
Okay. We are ready when you are.
Good afternoon, and may it please the court. Tyler Talbert on behalf of the appellants, Metwater Vista Ridge, as well as those 3 additional non-party appellants that were named in the final judgment. With our time today, I've tried to collapse the issues into 3 big points, and those are these. Number 1, early venue error warrants reversal and remand and transfer to Travis County. Number 2, factual and legal issues should have precluded the 3rd grant of summary judgment and the resulting final judgment. And 3rd and finally is that the entry of judgment against parties and non-parties alike was error. Now, the benefit of this structure is that an affirmative finding on issue 1, the venue issue, eliminates the need to go further. So let's jump right into that first one. The trial court erred by failing to transfer to Travis County, which was an agreed upon mandatory venue. And I think the court can make its way through this argument.
Wasn't the venue Travis or, not mandatory in Travis, but it was Travis County or another county?
It did say, the 2008 assignment said, exclusive venue shall be in Travis County or the domicile of the defendant, Metwater. Yes. And so that's important when we talk about the structure of where it should have gone if it was improper, right? And so it has a clause that says Travis County or. What happened was the Metwater parties both asked transfer to Travis County. Burleson, where the case began, was not proper. At that point, we know, based on Henry Masonite, based on this court's holding.
But they also said Washington was proper.
What they said was, in the alternative, Burleson can't be correct, right? Take Blue Water at their word. They are alleging that Washington should be proper. And so if their own allegation is saying that Washington is not proper, Burleson cannot be proper, and the only remedy is to transfer to the county specified in defendant's motion, right? But the trial court didn't do that. It transfers it to neighboring Washington County over.
But in the motion it said Travis or Washington.
It did not. Both parties solely requested transfer to Travis County. Now, the language you're referring to in the second amended motion to transfer venue, they say in the alternative, right, under Rule 48, they say Washington would be proper to demonstrate that Burleson was. But if you look at both parties' requested relief, both parties expressly say transfer to Travis County. The trial judge didn't do so. Instead, it had 2 holdings or 2 findings. It said, number 1, I don't think this venue clause applies here. Okay? It says, number 2, I find a mandatory injunctive relief provision trumps that.
So for the 2008 partial assignment, who were the parties to that?
The parties were Metwater, the Metwater LP and the Blue Water parties, not Metwater Vista Ridge.
How does that affect your argument?
Factually, procedurally, and legally, I don't think it presents any impediments. Let me walk through each of those and tell you why. Factually, here's why. There's a 2016 post-closing agreement which all parties signed. Metwater Vista Ridge signs. And it contains this language. It says, we affirm, we ratify, we consent to all existing agreements, expressly listing the 2008 partial assignment, right? So it reaffirms and it's bound by those obligations. Factually also is, if you look in the 2008 assignment, it's got this broad binding on successors, assigns, representatives, right? And this sort of segues me into the procedural aspect. Blue Water's never made this argument that you weren't a party to the 2008 assignment. Why? Because their whole theory of the case is all of you Metwater parties are one and the same. Y'all are all playing games and y'all are functionally one and the same. They've never said you can't apply this because you weren't a party to it, because it's at odds with their entire theory of the case, right? And then legally, under 87.5, that being Texas Rules of Civil Procedure 87, paragraph 5, Metwater Vista Ridge filed a timely motion to transfer venue and said, we are preserving all of these issues for appeal, right? That there was a mandatory venue selection clause that should have been enforced at the outset.
But you keep calling it mandatory when there's 2 choices.
Correct. There were 2 choices. And
So it's not mandatory, it's two choices, and the judge picked Washington.
you can have more than one mandatory venue. I completely concede that. But the issue is, what is a trial court's obligation when it's presented with a motion to transfer venue and it decides that venue is not proper where it is?
And the clause says Travis or Washington.
Right. And so the answer we know from Henry Masonite is to transfer to the county specified in defendant's motion. That was it. That's the error.
VR didn't get a ruling, right, on their,
It did not. Under the language of Texas Rule of Civil Procedure 87.5, they were actually precluded from having a hearing on it. And if you read 87.5, and I'm happy to pull it, it says, but filing a timely motion preserves the error for the purposes of appeal. And that's precisely what they did and what they're pursuing now. But as to your question, Judge, you know, the procedure here and the timing is fascinating because you have January of 2020, the Henry Fox River holding comes out, right? And it's trying to bind Metwater parties to Washington County under this injunctive relief provision. Supreme Court of Texas says, no, we're not going to do that. 3 months later, you have the same attorneys shoehorn another claim against Metwater into an existing suit in Burleson County, trying not to make the same mistake twice, right? Because an injunctive venue provision, just like that one, was no good. And so instead, they file it into the Osley suit, which clearly implicated the 2008 assignment, right? We're talking about the same obligations. We're talking about the same agreement. It's Exhibit A to that petition. And so our submission is simply this. Court doesn't even need to come to the 65023 issue, right? We don't have an issue where we have to address a head-on clash between the injunctive venue clause and the major transaction clause. Once venue was improper in Burleson, the case had to be transferred to the place specified in defendant's motion. And the failure to do so was error warranted.
does your lawsuit arise from the 2008 agreement?
It does.
Assignment?
It does. And when we talk about whether a lawsuit arises from, the Supreme Court have told us is what that means in Henry Fisher, right? They say it's a common sense analysis. Are you seeking to enforce common law obligations or obligations that arise from a specific agreement? I would urge the court to take a look at Blue Water's own petition, right? This is paragraph 1, and here's what they say. We got our ownership interest via the assignment. What assignment? The one they attached as the Exhibit A, the 2008. They say our allegations are these. Metwater had an obligation to manage and administer the assigned leases, and they didn't do it. They had an obligation to make payments to necessary owners. They didn't do it. They had an obligation to disclose necessary information. They didn't do it. Where are those obligations coming from? Let's look at Exhibit A, paragraph 31. Metwater shall manage and administer leases. Metwater shall make payments. Metwater shall disclose information. They are suing based on obligations contained in the 2008 assignment. You know, I couldn't say it any better than they say in paragraph 10 of their own petition, right? They say this. They say, this case involves Metwater's assignment of leases and failure and refusal to comply with the terms of the assignment. That's their case. That the assignment was breached, right? It clearly fell within this provision, and yet we had venue in Burleson County get transferred to Washington improperly. I see I've burned up far too much of my time that I've intended to. I do want to turn very briefly to the summary judgment issue, and I think the court is aware of the issues, and I just wanted to flag 2 of them, and those are these. That the trial court construed the existing the new leases provision in a way that grabbed up leases that were neither in replacement of nor in connection with the VR leases, and we submit that was improper. And second, the 2016 letter
What leases do you say were not in replacement of?
We identified 5 leases in the appellant's brief. Those include the Janetta Lynn Robinson leases, the Van Gaunten leases. I've got all 5 here.
So you're saying they weren't original Vista Ridge leases?
We're saying that at the time that they were signed, there were no existing leases to replace. My submission is simply, you can't replace something that doesn't exist.
Okay, but they were leases that you were supposed to keep in trust because they were Vista Ridge leases.
At the time they were signed in 2020, there were no existing leases on any of those 5 properties, to be abundantly clear. And our submission is simply, you can't replace leases that don't exist.
No, but I'm asking you about the 2 other sentences in that paragraph.
Or in
about
connection with?
No, all leases are in trust.
Of the section 2.7 of the post-closing agreement?
Yes.
It obligates Metwater to assign.
No, I'm talking about all leases. All Vista Ridge leases are in trust for Blue Water.
Correct, I agree with you, and I hear you.
And so these 5 leases were in trust for Blue Water.
That's precisely my question, is how as a matter of law did Blue Water conclusively establish that these were VR leases? They weren't existing leases at the time of the post-closing agreement. They weren't attached as Exhibit A as all identified leases. How were they in connection with? Were they subject to some geographic span, some temporal proximity? What does that clause mean such that these 5 leases, on which no leases existed when they were signed, are, quote, in replacement of or in connection with? Or were some of these in trust leases? Simply that, Your Honor. And then also the limitations issue. That in 2016, Scott Carlson sends letters saying certain leases are not subject to Vista Ridge. I can talk about transferring or assigning them back to you once you quit breaching the agreement. They wait 5 years to sue Metwater Vista Ridge.
What is the evidence that the letter was sent?
So the letter, which we've included at tab 3 of the bench book, it also comes with an affidavit in which Scott Carlson says, look, these are true and correct copies of the documents. They were made at or near the time. They're kept in the regular course of business.
It never says they were sent.
It never says expressly they were sent. 2 points there, though, Your Honor, is number one, when you read the letters, he says, as we discussed, right, you've got factual disputes as to whether these conversations happened both verbally and then in writing. Also, when you go, well, I'm just not sure.
But the affidavit doesn't say I discussed at that time.
The affidavit does not say that. The letter does. But when you've got a dispute going, well, did he send the letters or not? You're resolving all doubts in favor of the movement to go, well, I don't think, I'm going to conclude he didn't send it at that time. On a summary judgment standard, that's something that a jury should resolve.
You have the burden of proof on limitations.
On limitations, that's correct. The burden of proof to raise a fact issue, right?
I don't see the fact issue if you didn't prove it was sent.
Well, he says these are true and correct documents.
Or that there was a conversation. He didn't swear to either of those facts.
Understood, Your Honor. With the 30 seconds, just to be brief, is our final issue is that the entry of judgment against parties and non-parties alike was improper. Whether it's under Rule 122, which requires you to sue, cite, and name parties you want to name in a judgment, Rule 39, which requires you to add all necessary parties, Rule 122, which requires you to quash when there's not appropriate service. Under any of those, that none of those allow for simply sneaking in non-parties into a judgment at the 11th hour. And for all of those reasons,
How do you rebut his argument that you're a party after appearing?
So I think the simple answer there is you grant the motion to quash. And I see I'm going to go over if I could briefly answer. The simple answer is you grant the motion to quash, right? You don't just proceed as if no motion to quash had been filed. I think an appropriate remedy on remand would be to say, you parties, having now filed this motion to quash, here's your answer deadline, mount a defense. That's what we asked for in the first place, was a chance to mount a defense, not to simply run roughshod over all these procedural safeguards. Thank you, Your Honor.
May it please the court, Ryan Green on behalf of the appellees. I'll start with some of the low-hanging fruit there. First of all, that argument about in connection with and replacement of. We have affidavit testimony that says all 7 leases fall under that, and they did not raise that argument. You won't find that argument anywhere at the trial court level. That's a new argument on appeal, so that's waived. Limitations. As Chief Justice Christopher, Justice Boatman, as you both indicated, there is no evidence that those letters were sent. And here's why that's key. There is evidence they were not sent. Again, affidavit testimony, Blue Water, in the record says they stayed silent until early 2021. Never told us anything about these Baldwin leases. If they wanted to raise a fact issue, they needed to put in evidence that controverted that, and they did not. All we know, if we're going to take as true what's in the affidavit, is he typed that and put it in his file and it's in his records. But did he send it? Did he have discussions with us? Uncontroverted summary judgment record evidence says that never happened. Because it's uncontroverted, there's no genuine issue of material fact on the issue of limitations. We prevail. Now, that's...
Do we presume the letter was sent based on the date? I know we have a presumption that it was received, but I didn't see anything about whether it was sent.
You can't have a presumption that just because something's in his file means it was sent. When we put at issue, we never got any communication from you. He needed to say out loud in testimony, I sent this to you. Not, I have this thing, See this thing that's in my record? I have this thing, and that's nowhere to be found. But there's also an alternative argument. Even if this court were to decide, you know what, there's a fact issue here, maybe this was sent, we'll give them the benefit of the doubt, there is still the question raised of when did limitations accrue, and limitations doesn't accrue on a wrongful act. It begins running, when there's an injury from that. There was no injury on this until we find out it's not just that he's taking this lease, but that he's not going to give it back, that he's actually keeping it away from the Vista Ridge project. Because remember, the post-closing agreement says, even if you take a new lease, it's held in trust for Blue Water, and you have to assign it back to Blue Water. Just 2 months after that September 2016 letter, in October 2016, he signs something that says all Vista Ridge leases are safe, don't worry. 2018, he signs the non-disturbance agreement. Don't worry, all Vista Ridge leases are safe. 2020, he's in court. His attorney is arguing to the judge and said, don't worry, judge, all Vista Ridge leases are secure. You're not going to hear any argument from us. They're all held in the trust. And then it was a year later, in 2021, when all of a sudden, lo and behold, these Baldwin leases show up. So we have no way of knowing that there was any injury whatsoever until 2021, when his letter shows up saying, haha, just kidding what I said in court. I actually have a lease, I'm not giving it back, and you owe me money. That's when the injury happened, and we promptly filed suit within 3 months. So even if those letters could some implication that they were sent, but you can't do that because there's no evidence at all that they were sent by Metwater or received by Blue Water. All right, venue. There's 2 independent reasons why this does not go to Travis County. There was no error in not sending it to Travis County. One is that 15.020 does not apply in the first place. That's a point you raised as far as do these claims really arise under the partial assignment. There's a misunderstanding about what that partial assignment document is versus the full assignment in 2014 that let me clarify this because it's critical. The partial assignment still exists as a valid contract for some leases. When it was entered, all leases owned by Carlson, by Metwater, were still owned by Metwater, but Blue Water got a partial assignment of marketing rights, all leases. In 2014, that changed. All the Vista Ridge leases were pulled out of the partial assignment by the 2014 full assignment. At that point forward, and the 2014 assignment agreement says this, at that point forward, the Vista Ridge leases were no longer subject to the Groundwater Resource Marketing Agreement or the 2008 partial assignment. They're now under the 2014, and there's no venue provision there. So if this was a case involving the 130 project, which is the other groundwater project, that's still subject to the partial assignment. Now you would have an argument that perhaps Travis County is a mandatory venue, but the Vista Ridge leases are not subject to the partial assignment.
So why was it cited in your petition?
We were providing background because it raises the question, how have we been in this relationship with Metwater for decades, over a decade, if the assignment just happened in 2014? And what happened is we had a partial assignment before 2014 that gave us the rights, partial rights to the leases. That's how we got the Vista Ridge project going. But in 2014, the relationship fundamentally changed on the Vista Ridge project. And here's the key. In that pleading, our live pleading at the time of the venue provision, look at the relief we asked for. All of them are talking about the 2014 assignment. None of them are talking about the partial assignment. So yes, the partial assignment still exists. It just doesn't govern the Vista Ridge.
So you're saying it was, the 2008 was discussed in the background section, was it in the argument section as well, but not in the prayer?
It's intro. It's not in the argument or the prayer. When we're talking about the assignment in the argument, we're obviously talking about the 2014 full assignment because that's where our rights now in the Vista Ridge is. It was just there in background. And like I said, you're not going to find a single claim, request for relief, and then look at the final judgment. See if there's any mention of the partial assignment or groundwater resources marketing agreement. 2014, the relationship fundamentally changed on the Vista Ridge project, and this specific dispute is solely about the Vista Ridge project. Now that's just one way we win on venue. The other way we win is that 65.023 trumps. That's the Fox River case. If it applies, it does in fact supersede the contract provision. And in this case, Blue Water put on affidavit testimony of the 2 key points. Number 1, our lawsuit is primarily injunctive. And number 2, Metwater's domicile is in Washington County. And in response, they did not contest either of those points. They said, okay, we'll take you at your word. That means mandatory venues in Washington County, which is why the court granted their motion and transferred it to Washington County. Appellant makes this argument that, yeah, but I didn't ask for Washington County. I asked for Travis County, and I get what I want. But that's not the law. The way the law works, and this is 15.063 in the venue statutes, it says on a motion to transfer, you transfer the case to a proper venue, a county of proper venue. And then section 15.001 defines proper venue as if a mandatory venue provision applies, that is the only proper venue. So in other words, if 65.023 in fact supersedes any contract provision, and Metwater conceded the key points on that and even said out loud in their pleading, therefore Washington County is a mandatory venue, the mandatory venue. At that point—
That was alternative relief, wasn't it?
It was alternative relief, but those 3 points, remember, Metwater did not contest that our lawsuit was purely and primarily injunctive, and they did not contest that the county of domicile was Washington County, and not saying in the alternative, but the very next paragraph they said, therefore venue is mandatory in Washington County. Once they say that, that becomes the only county you can transfer the case to. Now, their other argument that Travis County was mandatory, that was only under 15.020, which is trumped, which is superseded by 65.023. So once they conceded that 65.023 applied, whether in the alternative or otherwise, that meant that was the mandatory venue, not Travis County, even if the contract applied.
What about, didn't y'all, so y'all amended your pleadings after that and,
Yes.
and sought damages, so how do we deal with those?
Well, I think what you do is you start by, you look at the state of the record when the motion for transfer was heard, because the court couldn't predict future pleadings. And so with the pleadings that were before the court, there's no question the relief was primarily injunctive. Again, just look at the relief requested. We have these introductory declarations with all these injunctions. Now, since then, we have this case that's been severed. So what are the live pleadings today? We don't have any of those damages. That's back in the main case. We're past that. And so the actual judgment you look at, once again, we have a situation where it's clear that our relief sought is purely or primarily injunctive. And so to the extent there was some middle period where they could have reasserted a motion to transfer venue, they never did that. And now we're here with a judgment and live pleadings that, just like when the case began, are purely and primarily injunctive. So that's the venue issue. Whether you rule on that based on partial assignment doesn't apply at all, or whether you rule on it based on 65.023, the district court did not err in transferring the case to Washington County. I think the most interesting aspect of this case to me is the quote-unquote non-party issue. Rule 683 and case law in general is clear that when you have an injunction against a company, it's not just the company that's enjoined. You also have the officers, agents, employees, servants, attorneys, as well as anyone in active concert or participation. And you have to do that. U.S. Supreme Court—
But they're not normally listed in the judgment.
Exactly. And that's exactly where I was going, Chief Justice Christopher. That's what makes this interesting, is we added 8 words, including William Scott Carlson and Petroleum Leases, Inc., right? If we didn't—
And that seems to run afoul of all those other statutes that say you can't put people in the judgment unless they were a party.
And so that's the question, right? So if you remove those 8 words, this judgment is, we know it's fine under the case law, because if Metwater is bound by the injunction, so are its agents. So are those in active concert, right? And so then the question is, can we name 2 entities or individuals as falling within that group of agents, employees? And so what we're doing there, in other words, the point is, we're not saying, Scott Carlson, you are liable as a defendant. You are liable in a standalone capacity as you. We're saying, Scott Carlson, you fall within this group of officers, agents, servants. And it's because of that we're naming you. Not
Well, is that what,
Go ahead.
is that what the judgment says, or does it say it's active?
Yes, that's why it says including. And if you
But
look—
does that, which one does it modify?
that entire group, in other words, the officers, agents, servants, employees, attorneys, and those in active concert or participation who received notice, That group, we're saying both Mr. Carlson and Petroleum Leases Inc. fall within that category. Now, that doesn't mean that things can't change. So let's say that Mr. Carlson decides to move on with his life, and he's no longer affiliated in any way with Metwater and Metwater Vista Ridge. And then we try to pursue contempt proceedings against him for somehow violating the injunction. He would be able to show up in court in defense against the contempt proceedings and say, I was an officer then when this judgment was entered, but I'm not now. So I don't fall within the category of Metwater or Metwater Vista Ridge anymore. He still has the ability to do that.
Why do you think he'd be able to do that?
Why do I think?
Yes, because the judgment says he is an agent.
Right, right. Well, you always have the
The
ability.
judgment says Petroleum was in active concert.
You always have the ability to go in and ask the court to modify the judgment based on changed circumstances, especially in the case of a permanent injunction. And he would have the right to do that. But what this judgment is saying right now is this category of people who we know are bound as within Metwater or Metwater Vista Ridge, Mr. Carlson and Petroleum Leases have been shown on the summary judgment evidence to fall within that category. Mr. Carlson, it's easy. He is an officer, and that's easy. With Petroleum Leases, we put on the evidence to show that it was same control by Mr. Carlson, and that when Petroleum Leases agreed to purchase the leases, he signed saying, I'm subject to the same obligations that Metwater Vista Ridge
So is there evidence he was in active concert or participation, or are you saying we don't need to decide that? I'm sorry, Petroleum Leases was in active concert.
The evidence that we have of Petroleum Leases being in active concert or active participation is that it is the same individual running both, and it's him as the individual control purchasing the same leases from one company he controls to another. And
Well, the bankruptcy court must have thought that they were separate entities. How else would they take Petroleum's money for VR's debt?
Right. No, I agree they're separate entities, but they're separate entities in active concert or active participation. That's the point.
What do those terms mean?
What do those terms mean?
I mean, the in concert cause of action requires a crime.
It's right. It's an aider or abettor, and that's the language of the U.S. Supreme Court talking about the same language. It's someone who's participating in the conduct that we're trying to enjoin.
How is buying something under the auspices and approval of a bankruptcy judge a crime?
Oh, it's not a crime. But that's where it's important to look at the order of the bankruptcy court. I've never seen this sort of language put into a sale order before, where the court just didn't say, yes, Petroleum Leases, you can go buy this. The bankruptcy judge understood what was going on.
Let me ask you this. You don't put Petroleum's name in the judgment because of all the reasons, all the other statutes that say you shouldn't. And Petroleum fails to sign over the leases. You sue. You give Petroleum whatever due process they need to say why they're not bound. Why isn't that the proper method?
That is certainly a proper method. And if this court decides to strike out those 8 words, or remand to strike out those 8 words, then that's the approach that we would be limited to do. But that is absolutely a proper method. There's no question. I see my time is up. Thank you, Your Honors, and we ask that the court affirm the judgment.
With my 3 minutes, I'd like to address 2 points, that being venue and the inclusion of the non-parties. I heard several arguments about why venue was not a problem. One of which is that the 2008 assignment had nothing to do with this case. Second was that maybe it was superseded, and third, this 65023 argument. From the outset, there had been a kaleidoscope of reasons as to why Burleson was proper. They said, maybe this is a landlord-tenant suit. Maybe it's proper. To be clear, to avoid making the same problem that was made in Henry Fox River, they shoehorned their case into an existing claims into an existing case 8 years old. There's no dispute Nathan Osley's rights were created under the 2008 assignment. And so while it was a clever way to maybe obtain venue from the outset, the entire origin of the lawsuit they filed in was the 2008 assignment. Then they cite obligations from the 2008 assignment. The second notion was, well, maybe a later agreement superseded it. Take a look at the 2014 assignment. It says not a word about superseding venue. Not a word. Don't just look at that. Look at the 2016 post-closing agreement, in which the Metwater parties acknowledge, consent, ratify, and confirm all the existing obligations contained in the 2008 assignment. You have a valid binding forum selection clause that applies there. Finally, the notion was that, well, 65023 should trump. As a precursor, we don't even need to get there, right? We transfer to the county specified in defendant's motion. And there was some question, well, what did they ask for? Maybe the Metwater parties wanted to be in Washington. I've got both Metwater parties' pleadings. Request, transfer to Travis County. Request, transfer to Travis County. That's what they wanted, and it was error to refuse to do so. Second, talking about the non-parties issue, you've been presented a groundbreaking position that Rule 683 can be used to bind non-parties. It's an escape hatch against every other rule of civil procedure.
Well, it can be used to bind non-parties. There's clear Texas Supreme Court law to that effect. You enter an injunction saying Commissioner's Court has to do it, and when two individual commissioners screw things up, then you sue the commissioners and say you were bound by that injunction. Clearly, you can bind non-parties.
And my question is simply this. If the entire theory of the case is Scott Carlson was the chief operator and perpetrator, why not sue him? Why wait till the literal 11th hour to try and name him in a judgment? He was a necessary party. Why? 683 doesn't allow for perpetual, permanent injunctive relief against named parties exactly as you had here. And the best I heard is, well, maybe we can fix it later if things change. They stood in front of the trial court and they promised...
Even if we took the name Carlson and Petroleum out of the judgment, you would still be bound if you were an agent or if you were in concert or participation.
I think I see I'm briefly going to
Go
go over
ahead.
time. I think the problem is shoehorning them in at the 11th hour and saying you're bound.
But
This is a motion.
you seem to be arguing that they wouldn't be bound. And my statement to you is they still would be bound even if not named.
My argument is simply if they're going to be bound, give them a chance to defend themselves. It's that simple. Thank you.
Thank you for your arguments. The case of Metwater versus Blue Water is submitted and we are adjourned.